Welcome to today's seminar on managing poor performance. My name is Sarah Townsend and I'm a partner at Duncan Cotterill's Employment and Health and Safety team in Christchurch. I'm going to be joined today in my presentation by Jonny Sanders, an associate in our team. Performance issues are very common in a workplace and they can be complex and time-consuming to work through. So today we're going to work through some of the issues and difficulties associated with managing a performance process. We're going to identify what a poor performance issue looks like and talk briefly about the legal framework for dealing with performance issues. Jonny will take you through a textbook performance management process before we then deal with some troubleshooting at the end. So first of all, identifying what poor performance looks like. Poor performance essentially is failing to perform to the employer's standards and requirements. A good first place to look to identify if an employee is meeting the performance standards you require is the job description. That will normally set out the performance indicators and the expectations of the job. However, of course, poor performance can take many other forms and can include things like not performing to instructions, tardiness, but can also deal with some of the more difficult issues such as attitude and conduct and, for example, how people interact with colleagues or customers. Poor performance and misconduct are two separate things, but they do look very similar in a number of respects. Jonny will talk through in more detail some examples of poor performance when he goes through the process. The legal framework is important to keep in mind. While this is an employment process mainly based on discussions between the employer and the employee, it is important to remember that there is a legal framework that sits above it. And that is because the employee is able to bring claims if he or she feels that they've been treated unfairly or not in accordance with their rights through the process. The Employment Relations Act is the main piece of legislation to consider when thinking about the legal framework, and it contains two very important provisions. First of all is the obligation of good faith, the duty of good faith. That applies to employers and employees in the relationship, but in terms of a performance management process, it requires employers to be open, honest and communicative with their employees. What that means is if there is an issue, there is a legal duty to raise this with the employee to explain to them what the problem is. The duty of good faith also requires employers to provide employees with access to all information that's relevant to concerns, and that can often involve quite a lot of information and documentation. It's important to remember that employees are entitled to this information, and in many cases requests for information are made through the process and, generally speaking, should be complied with. If you're in any doubt as to what you may need to provide to the employee, then it's a good opportunity to take some advice at that point. Just a word of caution at this early stage is that do be careful about what you put in emails, for example, between senior management and your HR team. All of those documentations are discoverable and relevant. They are often requested by employees and there is a legal requirement to provide them. So do give some thought as to what you put in writing. The second important legal consideration as part of the legal framework is the test of justification, which is set out in the Employment Relations Act. That is the standard to which employers are held when challenged by way of a personal grievance by an employee. So the test is whether the employer's actions were what a fair and reasonable employer could have done in all the circumstances at the time that the dismissal or other action occurred. So the other action that might occur would be, for example, a formal warning or some sort of a formal performance improvement plan. It's important to remember that the onus is on the employer to show that what it did and how it acted was fair and reasonable. It is not for the employee to show that they have been treated unfairly. The legal onus is on the employer to show that what they did was fair. So an important distinction. And then finally, before commencing any kind of performance process, it's very important to have a look at the relevant employment agreement and the policies that might be in place within the organisation. They will often set out a procedure, for example, that the company undergoes to follow when going through a performance improvement plan. So it's important to follow those policies. The courts have been clear that if an employer does not follow their own policies and their own employment agreements, they are unlikely to be acting fairly, and it is likely that any subsequent personal grievance will succeed. Now, these things are important because personal grievances can be very expensive and time-consuming to deal with, and we've seen in the last few years a significant increase in the levels of compensation awarded to employees who have been unjustifiably dismissed. So, for example, compensation for hurt and humiliation can often be in the $15,000 to $20,000 range, and with lost earnings awarded in addition. So it can be a very expensive process to get wrong, and is well worth taking the time and taking some advice to ensure that you get it right. So I'm going to hand over now to Jonny Sanders, an associate in our team, who will talk to you about the legal principles of going through a fair performance management process. Jonny, over to you.
Thanks, Sarah. So as Sarah said, I'm Jonny Sanders, and I'm going to talk through now some more important aspects of the legal principles, and in particular look briefly at a case that establishes the law around performance management. The case is back in 1993, and it's called Trotter versus Telecom. To give you a brief idea of the case, Mr. Trotter was employed as a senior manager for Telecom. He worked in a commercial senior role from around late 1990 through until mid-1992, without any particular issues being raised with him in relation to his performance. And indeed, through that period of around a year and a half, Mr. Trotter received bonuses and a number of communications that indicated that he was doing a good job. However, in the middle of 1992, Mr. Trotter received a new manager who took over responsibility for supervising his work. And things went pretty badly from there. The manager very promptly sent a communication to her own manager, raising concerns about Mr. Trotter's performance and the performance of others in the team. The manager also wrote a formal report to Mr. Trotter, raising concerns around his performance and indicated general areas of concern, for example, missing deadlines. But the manager didn't really explain any detail of what the concerns were or give any examples so that Mr. Trotter could understand where he needed to improve specifically. The manager, shortly after that, in August of that year, sent a further communication to Mr. Trotter requiring that he improve dramatically his performance within the next 2-week period. And otherwise, she said, she'll be forced to take further steps. Mr. Trotter's performance did not improve to her satisfaction, and within that 2-week period, the manager sought and received permission to terminate his employment, and as soon as the 2-week period ended, he was out of a job. Mr. Trotter took a claim for unjustified dismissal based on the employer's conduct and received monetary rewards in excess of $370,000, which is a lot of money now and certainly was back in 1993. What came out of that case, rather than the set of facts, is a number of principles that the employment court set down for employers in managing poor performance. We've got those listed there, but essentially the employee must be notified by the employer of specific concerns around their performance. The employer must also give a series of explicit and fair warnings before dismissal is contemplated. The employer needs to communicate to the employee specific and measurable improvements that the employer wants to see in the employee's performance. The employer must also give a reasonable opportunity to improve and should consider things like training and counselling to assist the employee to reach the required standards. And you can see from the facts of the case that a number of issues, but certainly the employer Telecom didn't communicate clearly what the required standards were. There wasn't enough specific information, and we often see that with employers in these processes. One of the major failures is to provide detailed information about the performance issues and examples so the employee can understand where they're going wrong. Also, in this case, the sort of 2-week or slightly longer, if you take the whole process into account, period for Mr. Trotter to improve was simply insufficient, and he didn't get clear and fair warnings before he was dismissed. So taking into consideration all the important legal points that Sarah's been through and this case I've just talked about, we're going to now talk briefly through an example of a performance management process that is likely to meet all those legal requirements. Now, it's important to note there's no one-size-fits-all here, and it's really crucial that, as Sarah indicated before, any employer must follow their own processes and employment agreements or policies, in addition to what I'm going to be talking through. But we've summarised this into a 5-step process of investigating the concerns, counselling the employee, getting into a formal performance management process, going through a warning stage, and then ultimately, if things haven't improved, considering dismissal. And I'll talk through all those briefly now. So the first step is the investigation. And this is what an employer does to prepare to address matters with the employee. It's important to determine really clearly in your own mind what the performance standards are. What is required of the employee? They need to be clear, objective, able to be measured, and of course be reasonable. For example, if you've got an employee whose performance issues relate to not meeting sales targets, that can be quite clear and easy to identify. In other situations, you may need to think carefully about how you're going to be able to identify the issue and also measure it. There's a case where an employer had a number of butchers working for them, and they were concerned that one of the employees wasn't working quickly enough. So what they did is they conducted a survey of a number of other butchers in the workplace, measured how long it took them to do particular tasks, and took into account experience, skill level, and then determined a standard that they could judge the employee by and could communicate to him, if you're doing this particular task, it should take around this long. And the court held that was a fair and reasonable way to approach it. Also, in your preparation to address matters with the employee, you want to consider relevant documents, look at previous performance reviews, and again, look at the employment agreement and policies. Also consider their training record, their experience, and most importantly, keep records of all the issues. It's really important to have specific examples that you can raise with the employee. So that's the first stage, and then you're ready to actually address matters with the employee. And what the courts expect is that you'll initially take an informal approach. We call that counselling. So you'd sit down with the employee, could be part of a regular catch-up that you have with them, and you'd go through and say, look, we've got some concerns, you're not meeting standards in this area, you'd want to clearly communicate what the issues were, and again, you'd want to provide detailed examples so the employee can understand what the issues are. As part of that conversation, it's also very important to ask the employee how things are going from their perspective. Do they identify there's an issue? And also, are there some things that could be fixed to solve that problem? There may be things in the employee's work or personal life that are impacting on their performance, and it's useful to find out about those things early in the process. Once you've had that meeting, and you may need a couple of meetings, you may start and get progressively more serious in these counselling sessions, but at a point you need to clearly warn the employee that if things don't improve in those specified areas, that they may be subjected to a formal performance management plan. Once you get to that stage, after that meeting, we recommend that you send a note, perhaps an email to the employee, so you've got a clear record of examples of the issues and a warning that if things don't improve, they may go to the next stage. After that meeting, keep documenting examples and keep keeping an eye on what's going on. The third stage is into the formal performance management process, and this requires a high degree of formality. The employee should be invited to a meeting. That invitation should be done in writing so you can show what you've communicated to the employee. There's a number of things which should be in there which you can seek advice on, but as a brief way of example, should identify that you want to meet with the employee to discuss some concerns with their performance. You should state the specific concerns and give detailed examples of what's going wrong. So if it's an issue around meeting deadlines, you say, you were supposed to have this task done on this date, but you didn't do it till this date. It's a simple example, but you can see the need to provide specific and clear information to the employee. Should also advise the employee in advance of the possible outcome of the meeting, which at this stage is likely to be a formal warning, perhaps alongside a performance management plan. You should also invite them to bring a representative or support person along to the meeting, and it's important that you do that. As Sarah mentioned before, there's a lot of obligation on the employer to provide relevant information, so with the letter should go relevant documents and examples. At the meeting itself, you want to discuss with the employee the concerns. The meeting is really a chance for them to give their view and their feedback on the concerns. It's important that you don't make any decisions at the meeting, and if, as well as hearing what the employee has to say about what might be causing the issues, also raise and discuss whether any training or support could assist them to reach the required standards of performance. After the meeting, and again, you don't make a decision at the meeting, you wait until after the meeting to consider things, and after that you can make a decision on what to do next. And if you're wanting to progress things further and you're not happy with the employee's explanation, you may then decide to issue a formal warning. And the warning needs to be carefully drafted, and we'd recommend that you seek advice, certainly at that stage. The court in that Telecom and Trotter case actually spoke about the needs for warnings to be explicit and to be fair. They need to describe what the unsatisfactory behaviour is and clearly identify what improvements are required. The court stressed that warnings are not to be seen as steps towards dismissal, but they're an opportunity to put the employee on notice that if they don't improve in a reasonable period of time, that may be the outcome. But the whole purpose of warnings is to avoid dismissal. So you want to keep that in mind in your communications with the employee. So the fourth step is that warning stage. A question we often asked is, how long do I need to give an employee to improve between the first warning and perhaps the final warning? There's no magic rule, and it will depend entirely on the circumstances. For things like attendance and punctuality returning from breaks or behaviour towards colleagues, you can probably expect an immediate improvement. A review after a week would be normally appropriate. However, for things like sales targets, if it's a quarterly sales target, you would be reviewing every quarter and give the employee that period of time to improve. Again, throughout the warning, throughout this stage, you need to, for each warning you issue, you need to follow that same formal process. A formal letter inviting the employee to the meeting, have the meeting, and not make any decisions until after the meeting. You want to continue to consider training and support and make sure what you've agreed to provide, you are providing, and have regular reviews, particularly if it's a long period of assessment, regular reviews with the employee to update them on progress. The final stage of the process is dismissal. Now, of course, the employee must receive, in the words of the court in Telecom and Trotter, a series of warnings before dismissal. How many warnings? We recommend at least 2, a first written warning and a final written warning. However, if your employment agreement or policy requires more warnings, for example, it may require before a first written warning a verbal warning, then you have to meet those obligations and you may have to do more than 2 warnings. Again, the courts have emphasised that dismissal is a last resort and you should make all efforts to help the employee improve their performance to the required standards before you'd go down that track. If that doesn't work, you'd have to go through a formal process looking at dismissal. You'd invite the employee to a meeting, and this time the letter would say that their employment may be terminated, and you'd hear the response after the meeting, consider, make a decision, and if you decide to dismiss the employee, then you would give them notice as required under the employment agreement. Right, now I'll hand back to Sarah to talk through some of the tricky issues and problems that can come up during this process.
Now we're going to look at some of the other considerations or curveballs that can come up through the process. So, for example, it is not uncommon for employees who are faced with the prospect of a formal performance improvement plan to take a period of stress leave and need some time off. It's also relatively common and increasingly common for allegations of bullying to be raised at a similar time to performance issues being raised with an employee. So, for example, an employee may say, in response to a performance issue being raised with them, that in fact they don't believe they're performing badly, but the issue is with their manager, who is micromanaging them and has been bullying them, and that's the reason for the issues. And in some cases, employees may refuse to engage altogether with the employers on the process for a range of reasons. It's very important at this stage for employers to not ignore those issues that are raised and to try and push on regardless, but to take a pause and to explore the reasons why the employee is raising these matters and whether there may be any substance to them. There may be, in some cases, perfectly good and valid reasons why explaining the employee's apparent poor performance. It can sometimes feel like a delaying tactic, and sometimes it is, but it is still important to take a pause and reflect and look into the issues raised. It's also quite common to see an improvement in an employee's performance while they're being actively performance managed, but for that performance to drop away again after a period of time. In those situations, you do need to weigh up how long has elapsed since performance has improved and then failed again. And in the majority of times, you may simply need to pick up again where you left off from the formal performance management process. If a long time has gone by, say 12 months or more, you may need to start the process again from the beginning. It's very common to have information requests and also challenges to the process at an early stage, particularly when you get into the formal performance improvement process and the potential for formal warnings being issued. And that's the time where employers are required to let employees know that they can have a support person or legal representative with them. And when legal representatives get involved, often there's a request for information. There is often also allegations that the process has been predetermined and that it is, for example, the process is a sham to simply exit an employee. Again, it's important to take these issues seriously, to not simply push on regardless, but to consider whether the information requests, for example, should be replied to. In most cases, they do need to be replied to. So it's important for employers to stay flexible through this process. It is a good faith process. It is important to remain open, honest, and communicative with each other. Often there are other considerations to take into account when dealing with a performance issue. For example, medical circumstances may be contributing to an employee's poor performance in the workplace. An example of a case on the slide, the FGH and RST, which is an employment court decision from 2018, is an example of one of those situations. The employer in that case had performance concerns with the employee and was endeavouring to manage those performance concerns through a formal performance management process. The employee had some medical issues and had been diagnosed with attention deficit disorder, ADD, and also anxiety, which she disclosed to her employer. And while the employer took a number of steps to accommodate the medical issues, it also continued to manage the performance issues that it was dealing with. Ultimately and unfortunately, the performance process only exacerbated the anxiety and then the depression that the employee was suffering from, to the point where she became extremely unwell. When the matter was looked at by the court found that the employer was wrong to push ahead with a formal performance process and that it was in fact dealing with a medical issue and should have approached the issue on that basis. So the employee succeeded in her personal grievance claim that the performance process that she had been subjected to was unfair. Similarly, in the second issue on that slide, OPI and Commissioner of Police, which is an authority case from 2019, the police pushed ahead with a performance process in circumstances where there had been a number of issues raised by the employee and that remained unresolved. So again, the authority found that it was wrong for the police to push on with a performance process without fully exploring what the other issues might be that were contributing to the situation. So these performance processes can be increasingly complex in the modern working environment, and it is important for employers to be flexible and to take seriously issues as they arise. Some common mistakes made by employers in the performance process, issues that we commonly see and that clearly also come through the courts. First and foremost is insufficient detail about the performance issues. Time and time again, what comes through is that the employer hasn't provided enough detail about exactly what the issue is with clear examples. It's also important to make sure that the information relied on is not stale or historical, but that it is recent examples. There can be a tendency in some cases to treat a performance issue as a, for example, serious misconduct issue by trying to escalate performance to negligence or recklessness. That can be extremely difficult to justify from an employment perspective, and generally speaking, employers should deal with performance issues as performance through the performance process, not through a disciplinary process. Also, do be careful about inconsistent messaging, particularly in large organisations where, for example, there may be standard letters that go out with a pay review thanking employees for their good performance and contribution over the year. That can be quite difficult to deal with then if an employer starts a performance process with an employee shortly thereafter. Similarly, there have been numerous examples through the cases of employees receiving a bonus based on their performance and then having a performance management process started. So those two concepts are not always compatible with each other. So do think about your messaging and your communications. The next step is to consider some alternatives to a performance management process. As you've seen, it can be a long process and a complex process to work through, which can take many months to resolve, either from getting the employee's performance up to the standard that's requested or moving to a situation where a dismissal might be fair and reasonable. So we're often asked about what are the alternatives, and we've noted a couple of them. So first of all, 90-day trial periods can be an alternative. Now, of course, they are only available to small employers at the moment, and that means employers with 19 employees or less. It's important if a trial period is going to be relied on, the trial period must be valid. It must be in writing in an employee's employment agreement, and that employment agreement must be signed before the employee starts work. Now, if you do have a valid personal grievance, they can be a very useful tool because an employee cannot raise a personal grievance for unjustified dismissal. They can, however, raise other claims, and it's important to remember that the duty of good faith still applies. And what that means is that if issues arise, or concerns arise in employment with performance, an employer must raise those with an employee so that they understand what's expected of them. Another alternative to going through a full and formal performance management process is what is called the fireside chat, or the negotiated exit. Now, this is a strategy that carries a high level of legal risk, but that can also be very effective in resolving employment relationship disputes at an early stage. These fireside chats are high risk because effectively what the employer is saying from the outset that they don't have any confidence that an employee's performance will ever reach the standard that is required, and that the employer would like to talk about an exit. So it's really important, if you're going to have that kind of discussion, that you go in with some level of confidence that the employee will be open to that discussion. Because if the fireside chat doesn't work and you are not able to reach a deal, that it is extremely likely that any process that you follow after that to try and manage performance will be unjustified, and that the employee will have a successful personal grievance against the company. So do plan ahead very carefully. This is an area where employers should certainly take some legal advice before having any of these discussions to try and mitigate the risk that is there. If you are going through a process and there is a dispute or it's not going well, you may want to consider mediation as an option to have a full and frank discussion with the employee about the way forward. Again, we wouldn't recommend that you invite the employee to mediation as the first communication that you have with them, because that would of course raise a number of red flags. So fireside chats can be a useful tool, but they do carry a high level of legal risk and you should proceed with caution. We would generally, as an option, it's not on any of our slides and that's because we don't recommend it. We don't recommend dealing with a poor performance issue by way of a restructure or a redundancy. That is also something that carries a high level of legal risk. The law around restructuring and redundancy has evolved significantly over the last few years, and there is a high bar for employers to reach in being able to justify a redundancy. So if there is a suggestion that the redundancy process is being used as a sham in order to avoid going through a full and fair performance process, it's likely that the court would award the employee a high financial award in those circumstances. So in conclusion, it's important to clearly communicate performance concerns to employees and also to document them as you go along so that you've got a good paper trail of the discussions that you've had. Don't delay too long starting a formal process. It's easy to get stuck in that informal counselling process, but do remember that there are still a number of steps that need to be taken even after you start a formal performance process, and at least 2 formal warnings before dismissal. So do bear that in mind when you're thinking about what the next steps should be. Do take care to consider medical factors or other issues that may be contributing to the performance issues that you're seeing. Look into them and don't push on with the performance process regardless. And as you'll have seen, it is a difficult and complex process, and we do recommend that you seek advice throughout the process so that you can ensure that you go through a full and fair process and mitigate your risk. If you do have any questions or would like to discuss any of these issues with Jonny or I or any member of the team, please do feel free to get in touch with us. Our contact details are all at the end of the slide. Thank you very much for watching.